The International Convention on Civil Liability for Oil Pollution Damage, or CLC, is achieved through a dual legislative framework. The Merchant Shipping, Oil Pollution, Act 1994, Act 515, which establishes the rules of liability and compensation. The Merchant Shipping Ordinance 1952, MSO 1952, which provides the broad enforcement powers and operational penalties. The origins of the CLC lie in the 1967 Torrey Canyon disaster. This incident exposed a major gap in maritime law. There was no uniform international system to ensure compensation for victims of large-scale oil pollution. The IMO adopted the first CLC in 1969 to address this. However, by the late 1980s, significant inflation and the increasing size of oil tankers rendered the 1969 compensation limits insufficient. In response, the 1992 protocol was adopted. This protocol entered into force internationally on May 30, 1996. Malaysia ratified the protocol on June 9, 2004, and it officially entered into force for Malaysia 12 months later on June 9, 2005. The scope of the CLC 1992 is highly specific. It applies only to pollution damage caused by spills of persistent oil. This includes crude oil, fuel oil, heavy diesel oil, and lubricating oil. It does not apply to non-persistent, or light, oils, such as gasoline or kerosene, which evaporate. The convention also only applies to a specific ship, which it defines as any seagoing vessel, constructed or adapted for the carriage of oil in bulk as cargo. This means the convention is designed specifically for oil tankers. The convention's primary legal tenet is strict liability. This means the registered owner of the tanker is liable for pollution damage regardless of fault or negligence. The burden of proof is simple for the claimant. They do not need to prove the shipowner was careless. They only need to prove a causal link, that the damage resulted from the oil that escaped from that specific ship. This strict liability can only be avoided if the shipowner proves the damage resulted from one of four, and only four, specific exceptions: an act of war, hostilities, civil war, or insurrection. A natural phenomenon of an exceptional, inevitable, and irresistible character. An act or omission done with intent to cause damage by a third party, sabotage. Or, the negligence of a government or other authority in its function of maintaining lights or other navigational aids. These exceptions are deliberately narrow and maintain a high burden of proof for the owner. The convention utilizes channeling of liability. This legal mechanism mandates that claims for pollution damage can only be made against the registered shipowner. This protects other parties, such as the crew, the captain, the charterer, or any salvors, from being sued for the same incident. This simplifies the claims process and, crucially, concentrates the insurable risk onto a single, identifiable entity. A major weakness of the 1969 convention was its limited scope, which only covered a state's territorial sea. The 1992 protocol significantly expanded this. It extends liability to pollution damage caused in the exclusive economic zone, EEZ, or an equivalent area, which can extend up to 200 nautical miles from the baseline. This ensures protection for a nation's vital economic and natural resources, such as fisheries and offshore ecosystems. The 1992 protocol, as amended, dramatically increased compensation and introduced a stable unit of account, the special drawing right, SDR, a currency basket defined by the International Monetary Fund, IMF, to protect the funds from inflation. The limits are calculated based on the ship's gross tonnage, GT. For ships not exceeding 5,000 GT, the limit is a fixed 4.51 million SDR. For ships between 5,000 and 140,000 GT, the limit is 4.51 million SDR plus 631 SDR for each additional ton. For ships exceeding 140,000 GT, the liability is capped at a maximum of 89.77 million SDR. The protocol also expanded and clarified the definition of pollution damage. This now explicitly covers the cost of preventive measures taken to prevent or minimize damage after an incident, reasonable costs for the reinstatement of the environment, and compensation for loss of profit arising from the impairment of the environment, such as documented losses sustained by fishermen or coastal tourism operators. It is critical to note the CLC's limitation that it only applies to pollution damage from persistent mineral oil. Spills of non-persistent or light oils like gasoline, or pollution from hazardous and noxious substances, HNS, like bulk chemicals, liquid gases, or even vegetable oils, are not covered by this convention. These substances fall under the separate HNS convention regime, which mirrors the CLC's principles but covers a wider array of cargo. The challenge for Malaysia is that while it has fully implemented the CLC for oil, it has not yet ratified the HNS convention. This leaves a major compensation gap for victims of a serious chemical or hazardous substance incident in our waters, meaning claims must be handled under general maritime law, which lacks the specialized fund protection offered by the HNS regime. In Malaysia, compliance begins before any incident. Section 81(1) of the MSO 1952 places a mandatory duty on every ship owner to ensure that the latest Malaysian legislations, notices, international rules and publications relating to maritime transport safety, security and marine environment are readily accessible on board the owner's ship. As per Section 81(2), this list of required documents is determined by the Director of Marine, often through Malaysia Shipping Notices, MSN, such as NPM 57/2005 regarding the CLC. Failure to comply with this single administrative rule is an offence. Under Section 81(3), the owner is liable to a fine not exceeding 25,000 ringgit. The specific liability for a spill is domesticated by the Merchant Shipping, Oil Pollution, Act 1994, or Act 515. Section 3 of this Act directly mirrors the CLC, making the owner liable for pollution damage from contamination and the cost of preventive measures. Section 4 of the Act codifies the exact same four narrow exceptions seen in the CLC. The entire regime is backed by compulsory insurance. Section 11 of Act 515 prohibits any ship carrying more than 2,000 tons of persistent oil from entering or leaving a Malaysian port or terminal unless it has a valid CLC certificate. This certificate is issued by the Marine Department, MARDEP, after the owner provides proof of insurance, known as a blue card, which is typically issued by a P&I club or other specialized maritime insurer. The blue card proves financial security for pollution liability. Enforcement is strict. Under Section 11(6) of Act 515, if a ship trades without this certificate, the master or the owner is liable on conviction to a fine not exceeding 50,000 ringgit or to imprisonment for a term not exceeding 4 years, or to both. Furthermore, Section 11(8) gives authorities the power to detain the ship if it attempts to leave port in contravention of this section. When a spill occurs in Malaysian waters, the MSO 1952, Part VA, provides a rapid and powerful enforcement chain. First, Section 306(1) establishes a clear prohibition on any discharge of oil. Second, the master is legally bound by Section 306(1) to report the maritime casualty immediately. Failure to do so is an offence carrying a fine not exceeding 10,000 ringgit. Third, the Director of Marine is empowered by Section 306(d) to issue a written notice to the owner, compelling them to take specific actions. Fourth, the penalties for failing to comply with that notice are still substantial. Section 306(1) imposes a fine on the owner and master not exceeding 50,000 ringgit for each period of 24 hours that the offence of non-compliance continues. In extreme cases of a maritime casualty, Section 306(2) of the MSO 1952 grants the Director of Marine the ultimate authority to direct that measures be taken to sink or destroy the ship or cargo, to eliminate the pollution threat. Finally, to handle the compensation claims, Section 23 of Act 515 gives the High Court of Malaya and the High Court of Sabah and Sarawak exclusive jurisdiction to hear these civil actions, allowing claims to be pursued efficiently within the national legal system. In summary, the CLC 1992 protocol creates a uniform international regime built on two pillars: strict liability and compulsory insurance. Malaysia effectively enforces this regime through a dual legal framework. The Merchant Shipping, Oil Pollution, Act 1994 provides the legal basis for liability and compensation, while the Merchant Shipping Ordinance 1952 provides the operational enforcement, from preventative onboard document checks to severe financial penalties and intervention powers. Together, these laws protect Malaysia's marine environment and its economic interests. Thank you for watching this video. Please like and subscribe.